Good morning, everybody. It's really exciting to see so many people here for Denver Startup Week. This is my first time at Denver Startup Week, so it's actually really exciting. I'm just going to go through some sponsors. My name is Erin Burns. I'm a healthcare attorney at Husch Blackwell and your unofficial MC introducer today. We're going to be listening to some of my colleagues here talking about the legal essentials navigating the Colorado startup landscape. Before I introduce you to my colleagues, though, I wanted to take a moment to tell you a little bit about Husch Blackwell. Husch is a national law firm with over 1,000 attorneys nationwide. We have 20 brick and mortar offices across the country, as well as a virtual office, our link. For nearly 100 years, we've been turning common practice on its head, continuously evolving as a firm that outperforms the competition with uncommon approaches to our clients' challenges in a complex world. We are dedicated to our clients' success, whatever that may mean to them, and provide full service legal counsel across key industries, including healthcare, energy, technology, manufacturing, transportation, just to name a few. Our broad range of expertise and deep bench strength allows us not just to represent startups, but really empower entrepreneurs. We guide early stage companies from the mere idea, kind of planning stage, to market presence, offering strategic guidance and a helping hand through every step of that growth process. And speaking of the growth process and being in good hands, you're going to be in good hands today with my colleagues, Keith, Owen, and Maria. Keith is going to go first. He's a senior associate focusing on labor and employment. He also has extensive civil litigation experience. He's originally from Illinois, and I'm from Wisconsin, but I forgive him for that because he's always got a really good food recommendation. And then next we have Owen, who is also a labor and employment associate. And a fun fact about Owen, beyond the fact that he focuses on AI and data privacy, a more fun fact is that he recently got engaged. And then we'll round it out with Maria, who, yeah, that's exciting. We'll round it out with Maria, who's a senior associate in the corporate group at Husch Blackwell. And a fun fact about Maria, and as a fellow dog lover, I love this. She has a German Shepherd named Hobie. And she's gonna summarize the Corporate Transparency Act for us. And then just as a note, our colleague TK was supposed to be here today to talk about privacy issues for startups, but she has COVID. So we included a slide at the end that just includes a little bit of privacy-related resources and her contact information if you would like to reach out to her directly with a specific question. So with that, I'm going to turn it over to Keith.
Hi, everyone. So I'm going to cover some fundamental employment tips and issues just to be aware of as you kind of get your organizations and your businesses launched and going. This isn't going to be a comprehensive breakdown of employment law. We don't have enough time, and I don't want to bore you to death. It's a big world out there, but these are just a lot of the issues that I think, a lot of organizations struggle with, big or small, and especially if you're starting up or if you've got kind of a fledgling organization, here are some just fundamental things to be aware of and be cognizant of, help you spot some issues and let you know to be cognizant of this is a potential landmine or something you might trip over. So do's and don'ts of hiring practices. Shout out to Will Ferrell and John C. Reilly for one of my favorite job searching scenes in any motion picture, but we like to keep it light at Husch Blackwell. First topic I wanted to touch on, just compliant job postings. I'm sure many of you have noticed over the last few years that the information that's included in job postings has changed. Colorado pioneered pay transparency in job postings, so the law now requires employers to include in all job postings one, a salary or pay range that they in good faith expect to pay for the position that they're posting. A general description of other compensation for that position, which could include bonuses, commissions, if you're going to pay by a day or piece rate or some other type of structure. And then 2, a general description of job benefits that will be offered for that position. 3, a deadline to apply for that position. Unless it's truly going to be constantly open, you have to put some type of deadline in there, and you can't just say, like, this position is going to be open until it's filled. That doesn't quite work. And then 4, the contact information of the individual that an interested applicant needs to reach out to with their application materials. Now, the law doesn't require you to externally post a job. You don't have to do that. But if you do, that information that I just outlined needs to be included. And while I mentioned that you don't have to externally post a job, there is an obligation to notify Colorado employees of job opportunities. So these are opportunities or job positions in your organization that you are currently or you anticipate will be vacant and that you're going to competitively hire for. So unless someone is going to be automatically promoted into that position in terms of like an inline promotion, like someone moving from level 1 accountant to level 2 accountant, where that's a natural promotion for them after a set amount of time or X achievements in your organization, but you're going to competitively like hire for this, then you need to notify your employees of these positions. And then the information I just outlined, like that needs to be available as well. And then when you're hiring, what information can you ask for from applicants and what should you stay away from? Colorado has a law titled the Job Application Fairness Act that prohibits employers from requesting or requiring an individual to include their age, their date of birth, their dates of attendance at or date of graduation from an educational institution, just because you can pretty easily deduce how old they would be or they are based off of that information. This is a very new law. It's not even a year old. So if this sounds strange to you or you feel like, hey, I've provided that information in the past, that's because before it wasn't illegal. You can voluntarily give this information. Employers just can't ask for it up front in the initial application. Although they can, after an offer of employment, verify age and that you're able to be employed in the United States with an I-9 verification. The employer may request or require like additional application materials, such as copies of like your school transcripts, and I realize that like a lot of that information can be deduced from there. They just have to notify the individual that the individual can redact that information, like that would be indicative of their age. Other information you can't ask for, wage history. I know that's a pretty common one. I think a lot of employers still kind of trip up on this. If you ask how much are you making at your current job or how much have you made at your last 3 jobs, a lot of times that's to slot you in at a certain range that will be maybe just a little bit above, but maybe not be the full range that they're willing to pay. Employers can't ask for that information anymore, so don't. You also can't ask for someone's criminal record in an initial application. So, or state in a job advertisement or posting that a person with a criminal history may not apply for the job. Now, there are some jobs where you can exclude someone for it. There are some jobs like legally you can't hire someone with a criminal background for, but you shouldn't ask for that information up front. You also can't consider someone's consumer credit information. You can do a background check and credit information if it substantially relates to the job, if you have like a job in finance, banking, things like that. And one other thing, you can't ask applicants to give access to their personal social media or change their privacy settings. I'm not sure if like that's something that happens a lot, but that's just also a rule that's out there. So the more you know. Next, employment agreements. I know a lot of companies love non-competes, non-solicitation agreements. This has become a hot button topic in recent years. I don't know if some of you are aware, the FTC tried to just ban non-competes. They put out a rule at the beginning of the year banning them. A federal court in Texas just struck down that rule, so it's not going into effect. But Colorado has its own rules as it relates to non-competes and client non-solicitation agreements. They're only allowed and enforceable if the employee is earning more than a certain salary threshold of annual cash compensation each year, and for the purpose of protecting the company's trade secrets. So they need to be narrowly tailored. In 2024, the non-compete salary threshold is $123,000 and $123,750, and that's annual cash compensation. So if you're paying someone, $60,000 plus vesting options that could potentially vest in like 5 years, that's not going to work for an enforceable non-compete agreement. And they need to be earning that amount both at the time they enter into the agreement, so now, if it's someone you're hiring now, plus the year that you're trying to enforce the agreement. And then as it relates to the non-solicitation of clients and customers, that salary threshold is lower. It's 60% of the highly compensated employee threshold, but that number is $74,250. And these numbers are going to change year over year. It's set by our Colorado Department of Labor and Employment, but just assume it's probably going to incrementally increase every year. There are no specific salary thresholds for a non-solicitation of employee provisions, like those anti-rating provisions. So those are still on their face valid and enforceable. And then in addition to these salary thresholds, when an employee enters into an agreement that has these types of covenants in them, they need to be given a separate written notice form that they're entering into this agreement. So it's just a separate document. It says, hey, it flags for them, you're entering into an agreement with such and such company. In Section 3 of this agreement, there's a non-compete. In Section 4, there's a non-solicitation of clients. And then you need to give them, if they're a current employee and you're giving them a new agreement, they need to have 14 days to review the agreement before it becomes enforceable. They should sign this separate written notice to acknowledge that they've received it. Or if it's a new hire, they also need to acknowledge that they were given this separate notice form before they entered into employment and accepted the contract with these restrictive covenants. I know it's a lot. If you have employees that aren't going to quite meet those salary thresholds, and I think just as a general good business practice, consider having your employees sign a confidentiality agreement that applies to the company's proprietary information and trade secrets. It's a really good way to protect your IP, and it achieves a lot of the same aims of a non-compete agreement without the hurdles we just discussed. So that's just another way to think about protecting your intellectual property. And then worker classification. I know this is a big one, especially for new organizations. Do we classify workers as independent contractors or employees? I get this question a lot from friends and clients. Is it okay to classify our workers as independent contractors instead of a W-2? Like any good lawyer will tell you, it depends. But I would say be very careful with this. In Colorado, the law presumes that an individual is an employee if they're performing services for another. You can overcome that presumption. You can establish that a worker is an independent contractor, but you have to show that they're free from the business's control and direction and how they're performing their work. The organization can set the parameters of the engagement. They can say, I want this deliverable by X date, and that's fine. That's not controlling the means and methods of how they do that. But it's totally going to be up to the independent contractor to determine how they kind of get to that end goal. So that's a big one in terms of the analysis. And then the other part of the analysis that Colorado courts like to focus on is this individual customarily engaged in their own independently established business? There's going to be a lot of factors there, but are they working for other companies? Are they free to contract with whomever they please? Can they set their own engagement and compensation rates? All of that. So strongly recommend that you have all your independent contractors enter into an independent contractor agreement. That will then create a rebuttable presumption that they're an IC and not an employee. That agreement should state that they're allowed to work for other companies. They are paid at a fixed or contract rate instead of a salary or hourly rate, that your organization is not controlling the means and methods of how they're performing their work, other than setting a completion schedule or a range of mutually agreeable hours. You're not providing them the tools or equipment that they need to perform their work, and that this individual is responsible for their own insurance, their own benefits, that you're not doing any of those things, and that you're paying this individual under their trade or business name. And then I realize that there's a strong appeal in not having overtime or covering additional benefits and having to pay insurance for employees. I know that's all overhead, especially for new organizations. But just be very careful with how you're classifying your workers. It's very penal to get employee classification wrong. Both the state and the Denver Labor Departments scrutinize worker classification very closely. And if they get any whiffs of misclassification complaints, it's going to be extremely onerous to have to kind of go through that process of investigation and audit. And the penalties can be, quite severe. If you've misclassified someone, they're owed their wages up to like a 300% penalty for a long period of time. So it's not something to mess around with. Then I'll quickly run through just registrations you need to be aware of as you're starting a new organization. If you're hiring employees for the first time, obviously get your authorization to do business in the state of Colorado from the Secretary of State. You should submit an application to the Colorado Unemployment Insurance Division after you run your first Colorado payroll. Pay those premiums on a quarterly basis. You should register with the Colorado Family Division once you have Colorado employees. That's the state's paid family and medical leave insurance program. Employees, once they earn $2,500 in wages over like an 18-month period, have to contribute from that. So those wages are deducted should be deducted automatically from their payroll. And then once you have 10 or more employees in your organization with at least one in Colorado, the employer also needs to contribute to that fund, so just be aware of that. If you have a third-party administrator or like a PEO who handles payroll for you and they take care of that, great, you don't have to worry about it, but make sure that they're on it. Work comp insurance, that's also required in Colorado once you have one employee in the state, so go ahead and get that. New hire reporting, this is mandatory, so once you've hired a new individual in Colorado, you have 20 calendar days after that person's start date to report that they've been hired. Then best practice for record keeping, you have to keep employee records for a certain amount of time. 3 years is that timeline. You should keep their name, address, their occupation, their date of hire, a record of their hours worked, so that's kind of reflected in their wage statements or pay statements, so make sure you have itemized wage statements that detail all of this. That's just a separate requirement under a wage law, and then you have to keep those for 3 years after that payroll period, so it's like a rolling 3-year period. Your employees get to access their personnel files once per year upon their request and once after their employment is ended. So you have to keep those records, even after their employment is over for a 3-year period. You can keep confidential information separate from their personnel files, you have to. So their medical records, if you get someone's medical records because they're asking for an accommodation request or they give it to you because they're taking paid sick leave or whatever, don't keep that with their normal personnel files. If you have confidential reports from their prior employer, keep that separate. If you have documents pertaining to an active criminal investigation or an active disciplinary investigation, that should all be kept separate from their normal personnel file. And then, yes, so that's it.
We're cutting you off. Hey, everyone. Well, as an employment attorney, and as you can tell from Keith's presentation, the employment laws in Colorado are incredibly complex. And just in, I'd say, the past 5 years, it's become so much more challenging for employers. So it's very complicated and challenging. So I specialize in employee privacy, which has been a nice segue into a lot of the AI regulations that we are seeing, or we have been seeing over the past 2 years, those being considered and a few that have passed. So I've been monitoring are tracking different regulations, laws in the U.S. and internationally around AI, as it is, it continues to be a hot topic. So for today, we're focusing on Colorado, which was the first state in the U.S. to pass a comprehensive artificial intelligence law. And I'm going to do my best in 10-ish minutes to tell you what it is and how it works. So first off, the bill, the law passed this past summer. As written, it won't go into effect until February of 2026. But in the meantime, it's very clear that a lot of the details are going to change. There's been a task force put together at the state legislature to specifically look at the bill that was passed and signed by Governor Polis to identify ways to make it better, to avoid unforeseen consequences. And then there's also going to be a rulemaking process that we're going to see in the Attorney General's office. So a lot of the details, I think, are going to change in this next year. And right now, you don't have to worry about compliance until February of 2026. All right, so in thinking about whether this law is going to apply to you or your business, the way that the bill primarily works is that it's focused on what it calls high-risk AI systems, and whether or not your tool, your system falls into that category depends on when the system is deployed. In other words, when it's being used. Does it make a consequential decision, or is it a substantial factor in making a consequential decision? One thing I'll just move on to the next slide, actually. So one thing to keep in mind with the Colorado AI Act is that at its heart, it's an anti-discrimination bill. So it's really seeking to prevent algorithmic discrimination. And so that's why there's this focus on consequential decisions. And these are all of the, what you see on the screen here, are all of the areas that the bill lists as if you're making a consequential decision in one of these areas, then your AI system is considered high risk. And you'll see in these groupings, employment, housing, finance. These are all areas that have a high risk, without AI, have a high risk of creating discriminatory results. So that's primarily what this bill is focused on. One just footnote to this part, there is one provision in the bill that doesn't apply. It applies to any AI system when it's being used to interact with the consumer, and essentially all the business has to do is disclose that fact to the consumer that they are interacting with, think like a chatbot, essentially. But that's just a very narrow provision in the bill that does not apply to these high-risk AI systems that make consequential decisions. Okay, so you have a tool, you have an AI system that can be classified as high risk. What next? So then what the law does is it basically has a bifurcated scheme of regulating developers of high-risk AI systems and then also regulating deployers, in other words, users of AI systems. And there are different obligations that attach to both. So if you meet the definition of a developer, you develop or intentionally and substantially modify an AI system. Now, those are the words I really want you to pay attention to are intentionally and substantially modify. That is one area that I think the Attorney General is really going to clarify in the next year before the effective date, because I can foresee scenarios where you might be considered a deployer of an AI system. You contract out with a company that provides you an AI tool. You're clearly a deployer. But once you start fine-tuning the AI model, if you start providing your own training data, a question comes up of, are you substantially modifying it? And if so, does that make you then also a developer, and then you have to comply with the developer obligations? Time will tell. Hopefully this is something that gets cleared up. You can see there some of the language from the statute. Obviously, there are, in almost everything I'm going to tell you and have told you, there are some exceptions here and there. We obviously don't have the time to get into all of those, but I'm happy to answer any questions you might have after the presentation. And then, like I said, deployer is basically, are you using an AI system? Is it going out? Are you using it with consumers, people in Colorado? So we get to the developer obligations. I won't go through all of these in much detail, but the duty of care, this is one that's going to be shared by a developer and deployer. And what that means is if you are developing or deploying a high-risk AI system, you have a duty of care to protect against algorithmic discrimination. A key phrase in the bill that I think is pretty important is that you have duty of care to prevent algorithmic discrimination from intended uses of the AI system. So, and that's something you see throughout the law. It's concerned about, I think, the problem we have with all of these, this burgeoning AI industry is that these tools are getting created and they're being used in ways that even the developers couldn't fathom. So what the law says is that if you're developing a tool, you are going to be responsible for any of the discriminatory results that come from the intended uses. So in some ways, it tries to narrow the scope of kind of liability or exposure, if you want to look at it that way, to what your AI system is meant and intended to do. A big part of the developer obligations are providing disclosures to deployers. And that's basically those disclosures are saying, hey, this is what our AI system is supposed to do. This is its intended use. These are the limitations. These are the foreseeable risks of algorithmic discrimination. And basically, documentation that shows this is how you're supposed to use the tool. Listen to us. There are some public disclosures where one to highlight is that as a developer, you have to provide kind of it's described as a top-level summary of the training data that your system uses, and that's a pretty notable one. And then finally, I said I wasn't going to go through all of them, and look at me. If you are, as a developer, if you become aware of a substantial risk of algorithmic discrimination that your AI tool can create, then you have to notify the AG's office, and you also have to notify deployers of your AI system. And you'll see that some of these are shared by deployers. So don't be blown away by the number of obligations for deployers. But there's a lot. Now, one thing to keep in mind here with the deployer obligations is that, because I think most businesses that are going to be using AI tools are going to fall into the deployer camp. So one thing to keep in mind, though, is that a lot of your obligations as a deployer rely on what the developer has given you and told you. And that's purposeful. The law is built that way. It wants developers to be mindful of the risks of algorithmic discrimination, identify those risks, identify ways to mitigate those risks, and then inform deployers of the same so that they can protect against discrimination. So again, the duty of care also applies to a deployer. One thing I forgot to mention, with the duty of care, what the law says is that, if there's ever a question about whether or not you satisfy your duty of care as a developer or a deployer, there will be a presumption that you did if you follow all of the other obligations. So if you are making the necessary disclosures, providing the necessary notices, then there is a presumption that you have followed the duty of care. Of all of these, what's to highlight? Consumer rights is one that is getting some attention. One of the obligations for deployers is that if you are making a consequential decision with an AI system you've used, then a consumer, a person who's affected by that decision, can appeal. They can appeal the decision. They can ask you to. They can ask that you correct it, or they can ask you to appeal it for human review. So think of it in like financial lending. If somebody is denied, if you're using an AI system to deny somebody a loan, a business loan, a home loan, then that person might be able to ask to appeal that decision. And you have to, as a deployer, explain the decision and then follow the appeal process. All right, so I'm running out of time. So what to do now? So first and foremost, if you're using AI tools, great, but do your homework. You want to analyze what AI tools you're currently using and tools that you're considering, and just understanding the risks involved and how they work and whether or not they would fall into the high risk category of making consequential decisions. Contracts. This is a big one that our firm is working on a lot right now. There are third-party service providers that maybe you're already using their services and now they're implementing AI into the software that they provide you. We're helping clients with contract negotiation, making sure that when it comes to some of the compliance measures required by Colorado's law or other laws, that the burden is falling on the right party. And there's indemnification comes with that, and just pushing liability. Risk management program, and then the last thing I just want to say is stay informed. Pay attention to what the AG's office does, pay attention to what the legislature does in terms of making changes to the law, and then also look at other states. We are seeing, I think there were at least 15 states last year, including Colorado, considered bills regulating AI. Most of them did not pass this year, but we're going to see them again next year. And all bets are on the fact that Colorado's bill, because it was the first one to pass, is now going to be a model that other states are going to use throughout the country. And that's even more likely given that we're seeing like very little movement at the national level for federal legislation on the topic. All right, I think that's my time, so thank you all for coming today.
Thank you. All right. Can everyone hear me okay? All right. I am going to talk about the Corporate Transparency Act. Like Aaron said, my name is Maria Bach. I am a corporate mergers and acquisitions and securities attorney at Husch Blackwell. Something to keep in mind with the Corporate Transparency Act. This law just went into effect as of January 1 of this year. So we don't have a ton of information other than what the agency putting this law into effect has told us. So what I'm about to present is the information we have as of today. This is not the gospel, so things might change tomorrow. But just keep that in mind. I think that's a good thing to keep in mind with all of these topics. They're very rapidly evolving and changing areas of the law, so just keep that in mind in general. All right, so some quick facts about the Corporate Transparency Act. Like I said, went into effect January 1 of this year, and it's aimed at making it harder for bad actors to hide or benefit from money that they're running through shell companies or other opaque ownership structures. And so in doing this, the Financial Crimes Enforcement Network is requiring most entities to file informational reports on the humans, the natural persons, the individuals who own and form various entities throughout the United States that are formed in the U.S. and operate within the U.S. So as far as compliance deadlines go, if your entity was formed prior to 2024, you have to comply with this law or confirm that you're exempt by before January 1 of 2025. So we're coming up on the deadline here. It's in a few months. If your entity was formed in 2024, you have to comply within 90 days of formation of your entity, and then going forward in 2025, you'll have 30 days to comply once you form a new entity. So again, this is a law that's going to require your entity to file a beneficial ownership information report unless you are exempt. And I'll get into the exemptions. The info that you file will then be available to government officials for purposes of law enforcement, intelligence, national security. It's not necessarily like when you file your, form your organization in the first instance and you can go onto the Colorado Secretary of State website and search for your entity and see what date it was formed. You can look at the filing. It's not like that. Someone's gonna have to go request the information, but it is available to be requested for those purposes. All right, sorry, trying to juggle clicking, flipping, holding the microphone. All right, so who has to report under this law? Any corporation, limited liability company, or other similar entity created by filing a document with the Secretary of State or other similar office in any territory or state of the United States. So that's a pretty wide net. The other similar entity captures limited partnerships, statutory business trusts, doesn't probably include sole proprietorships, general partnerships, certain types of trusts that are not created by the filing, by a filing with the Secretary of State or similar office. But like I said, it's a very wide net. Most small to mid-sized businesses are going to have to do one of these filings, so it's important that you're aware that there's this new filing obligation for you to comply with. If you are one of these entities that is required to report, I'll just keep repeating it so, you know, maybe eventually it'll stick by the end of the presentation. You're gonna be required to file a beneficial ownership information report, which is gonna provide information on your beneficial owners of your entity. What's a beneficial owner? There are two ways you could be a beneficial owner of an entity. You could exercise substantial control over that entity, or you could own or control 25% or more of the equity of that entity. Substantial control is a defined term. It's a little bit of a gray area right now because we haven't had a lot of enforcement. There's no case law on this law, so we're not sure exactly what it means, but this is the information we've been provided thus far. Someone who exercises substantial control could be a senior officer, so think CEO, president, certain other C-suite individuals. Someone who has the authority to appoint or remove senior officers, so think board of directors, board of managers. You have the authority to direct, determine, or you have substantial influence over important matters of the business. And then there's this catch-all, you know, in elementary school English, you were told you couldn't use the defined term in the definition. They don't care about that, they do this. The catch-all says other forms of substantial control. So like I said, very gray area, lots of things can fit into these different categories. You could make an argument one way or another for a lot of people in your business. So it's kind of a gut check thing right now. I know that's not terribly helpful from a legal perspective, but I'm sorry, I don't have anything more to help with there. The other form, other way you can be a beneficial owner is ownership or control of 25% or more of the equity. That one's a bit simpler. That's looking up the chain of ownership to a human. So if your entity is owned by another entity, owned by another entity, by another entity, and then eventually there are some humans, they want information on the human, the individual. They don't care so much about the entities in between. Those entities might have to do one of these reports, but they're not concerned about that for purposes of beneficial ownership. The other thing to keep in mind with this equity portion is that we're talking about the fully diluted picture here. So it's including all types of equity, profits, interests, options, warrants, all that good stuff. All right, so what everyone wants to know, how do I get out of doing this? There are 23 categories of exemption. Generally, the way you can think about a lot of these categories is, can the government go find out who owns your business somewhere else? if they can, they probably aren't going to make you report. That's why this pretty much applies very much to small and mid-sized companies, because you're probably not filing a lot of information about your ownership elsewhere. Some examples of exemptions: certain publicly traded companies, companies in very highly regulated industries. You're giving your regulator all that information already. Investment advisors, tax-exempt entities, governmental entities. And then there's a full list. FinCEN.gov has the most up-to-date information. They're the people who've put this law in place. They're telling us what it means right now. So if you want to see all the other categories of exemption, have some information as to what each of those categories means, that's a good place to check. All right, so if you're not exempt, what do you have to report about each of your beneficial owners? For each beneficial owner, you'll have to give their full legal name, date of birth, current address, and then something like a government-issued ID that has a unique identifying number, so driver's license, passport, something like that, and a copy of that document. For entities that were formed in 2024 and beyond, you're also going to have to provide information about the company applicant, and that's the person who is directly filing the document that creates or registers the entity, or is primarily responsible for that act. It's nice that if your entity was formed before 2024, you don't have to do this, because if, let's say your entity was formed 10 years ago, you have to not only identify who filed the document 10 years ago for you, but also track them down and get all this information from them. It's not very realistic. So it's just for newly formed entities, that company applicant piece. The rest of it, hopefully, you have this information readily available about your beneficial owners, or can reach out to them and get that relatively easily. Another thing to keep in mind with respect to these reports is, if for whatever reason you have to be listed on many different reports, maybe you invest in a bunch of different companies and you have substantial control over all of them. FinCEN has come up with a FinCEN identifying number. It's like a username. You go to their website, you plug in your information once, and they spit out a unique number for you, and that's the number that you give each time someone says, I have to include you on my report. You give them that number instead, and then you're not sending around copies of your passport or driver's license to 6 different people who are filing the various reports for you. Keep in mind, though, this is a requirement for this report as a whole, but especially with respect to the FinCEN identifier. Anytime your information changes, you have an obligation to go update it. You have 30 days to update it. Maybe at some point they'll come up with some method to kind of give you a little push notification or something to help you out, but we don't have that yet, so just keep that in mind. All right, just to summarize again, like I said, if your entity is formed before 2024, the filing deadline is January 1 of 2025. We're coming up on that deadline. It's going to be here before we know it, especially with the holidays and all that, the election, everything. It's going to fly by. That being said, I did some of these reports about a month ago. The turnaround time to get a filing confirmation was about, it was less than a day. That's not going to be the case the closer we get to January 2025. There's no expedited filing option here. This stuff is handled on a first-come, first-served basis. So the longer you wait, the more likely it is you're going to get that filing confirmation after January 1, 2025, which you don't want to do that. You want to get it before. So keep that in mind. If you have a lot of entities to file for, think about a FinCEN ID number to avoid sending around copies of your personal information to a bunch of different people. And then who can help you? Law firms can help. Professional registered agent companies, a lot of them have rolled out a service that will help you with this filing and navigating the filing. Certain tax advisors, wealth advisors, CPAs are also helping. It just kind of depends. You're also able to make this filing on your own by going to the FinCEN.gov website, so you don't necessarily need us. We're happy to answer questions, but you could do it on your own as well. And there's not a fee for the filing just by filing through FinCEN.gov. If you're having a professional service company help you, there probably will be a fee for their work, but the report in and of itself does not come with a filing fee. And like I said before, for more information, finsend.gov has a ton of great Q&As. Well, I wouldn't say they're the most amazing, but they're the best we've got right now. Q&As, frequently asked questions, a compliance guide, lots of resources. This is where we're all looking for information right now because there's not case law. Like I said earlier, things could change. I think all of us at the beginning of the year, all of us corporate attorneys were hoping that this law would get challenged and the compliance deadline would get pushed out. That did not happen. So, like I said, keep this in mind. Enjoy the rest of your week here at Denver Startup Week, and then on Monday, start thinking about this and figure out if you need to file or you're exempt, because it's coming no matter what. You can try to avoid it, but there are penalties. So just really quick on the penalties. Civil penalty, there's a civil penalty of up to $500 a day for noncompliance, and criminal penalties for willful violations are up to 2 years of imprisonment and a fine of up to $10,000. We'll see how enforcement goes in 2025, but I just wouldn't risk it. This isn't that burdensome of information to have to compile and provide. It's annoying, I understand, but just do the filing. It's in your best interest. Okay, and then really quickly, our colleague TK, Erin mentioned this, she was supposed to be here, but she has COVID. She was gonna present on data privacy. That being said, she provided some QR codes to some great data privacy resources. So you can scan these, and then they'll take you to, this one here will take you to Bite Back, which is Hush Blackwell's privacy law blog. So lots of great information, updates there. You can subscribe, and then it'll be delivered to your email regularly. And then this one right above my head is the state privacy law comparison tracker. It's updated periodically, but also a really good resource for new laws, state-by-state comparisons, things like that. And then TK's information is there too, but it's actually also on this slide. So for each of us on this slide, I think hopefully we have time for Q&A. I don't know what time it is.
You got a minute.
We have 1 minute. Each of our bios is on the left, and then LinkedIn is on the right if you want to connect with us, if you've got questions. We can take a question or two, I guess. Sure.
I just had a question for Keith around interns. So what are some of the do's and don'ts around interns in my role? And I guess maybe you want to share.
A lot of the same employment practice, like rules and kind of guardrails, are going to apply to your interns. In terms of, I know a lot of organizations have interns sign agreements and things like that. I'd be very careful with that. You can have them sign confidentiality agreements. That's totally fine. Obviously you don't want to create full-blown employment relationships with them, so be careful of the language around there. But a lot of policies and practices that apply to regular employees will apply to interns as well. So in a lot of senses, treat them like employees.
All right. Well,
Thanks, everyone.
thank you. Yeah.
Thank you.